Oh, okay.
Ambassador getting image. My lord, why you were about to get this guide, my lord? Just
No, maybe only one inmate at a time. Okay. I think we can see them now.
okay, my lord. Yes, ma'am.
Okay, Mustafa.
Good morning, my lord. My name is Mustafa Abana, Open Court Registrar, Federal High Court Damaturu Judicial Division. We are with the defendants at the Correctional Center, Pochiskum, for the proceeding to be started just now. First of all, let me affirm myself. I, Mustafa Abana, do solemnly affirm to interpret court proceedings from English to Hausa and vice versa to the best of my ability. So help me God. Thank you, my lord.
Do you have the course list with you?
Hello?
Do you have the course list with you?
Yes, I have the course list, my lord. If I can call the case, we'll start.
Yes, go ahead.
As the court pleases. Charge number FSC/DM/CR/54/2022 between the Federal Republic of Nigeria versus Abdul Hamid Yahaya and one another. Abdul Hamid Yahaya and Kawwa Shaibu. Just face me. Yes, my lord. The defendants are together without fear at the Correctional Center. What is for my lord?
Yes, presentation too.
My lord?
Presentation.
Representation.
Respectfully, my lords, my name is Usman Bamala and my humble appearance is for the complainants.
With profound respect, my lord, and humility, D.I. Indahi. My humble appearance is for all the defendants. May it please the court.
Yes, my lord. The defendants speak Hausa language.
My lords, the matter is selected today for mention. Subject to the convenience of my lord, we are ready to proceed.
My lord, we are equally ready to proceed.
Go ahead then.
Thank you, my lord.
Go ahead.
My lord, the complainant have filed a 2-count charges against the defendants. The charges is dated on the 17th day of October 2022 and filed on 18th day of October 2022. My lord, we apply for the content of the charge to be read to the understanding of the defendant, my lord. Thank you.
Okay. Filed on the council.
My lord.
Filed on.
My lord, filed on the 18th day of October 2022.
Yes, Abana, go ahead.
As the court pleases, zan karanta tuhuma da ake yi mawa. Kai zan fara da kai Abdul Hamid, karanta in fassara ma.
No, you need to read out at once. Let both of them listen to what you are saying. You don't need to read out one after, twice. It's the same thing.
Of 9 hours. On the 6th day of September 2022, during operations by NDLEA officers around mass transit inside New Market, Damaturu, Yobe State, within the jurisdiction of this honorable court, without lawful authority, conspired among yourselves to possess 500 grams of dried weed suspected to be cannabis sativa, substance similar to cocaine and LSD, and thereby committed an offense contrary to and punishable under Section 19 of the NDLEA Act. Zan fassara ma kai Abdul Hamid. Tuhuma da ake ma na farko cewa kai Abdul Hamid da ke unguwar Nainawa a Damaturu da ke yankin unguwar Tashan Mas da ke nan Damaturu a ranar 6 ga watan Satumba na shekarar nan da muke ciki lokacin da jami'an na masu hana sha da safara da miyagun kwayoyi suka kai samani wajen kun haɗa baki a junan ku kuka mallaki grams 500 na busasshen ganye wanda ake zafi tabar wiwi. Ka ji tuhuma ta farko da ake yi maka. Ka fahimta? Ka aikata ko baka aikata ba? My lord, the first defendant has understood the content of count 1, read and explained to him in Hausa, and he pleaded not guilty to it, my lord.
Let me ask him, because I didn't hear him answer. Do you understand the charge just read out to you?
Ka daga murya. Ka fahimci tuhuma da na karanta maka? He said he understood.
Since he said he understands the charge, how is he pleading to the said charge?
Ka aikata ko baka aikata ba? He pleaded not guilty to the count charge, the first count, my lord.
The second accused person, do you understand the charge just read out to you?
Kai kawo Shaibu, ka fahimci wannan tuhuma na farko da na karanta muku? Ka daga murya a ji. Equally understood
the charge, how are you pleading to the said charge?
Ka aikata ko baka aikata ba? He pleaded not guilty, my lord, the second defendant.
I can't hear him. I need to hear from him.
Ka daga murya sosai. He pleaded not guilty, my lord.
Okay, read out the second charge.
As the court pleases. Zan karanta muku tuhuma na biyu. Count 2, that you, Abdul Hamid Yahya, met adults and the Kawash Aibu met adults, both of 9 Ward, Jamatu, Yobe State, on the 6th day of September 2022, during operations by NDLEA officers around mass transit inside New Market, Jamatu, Yobe State, within the jurisdiction of this honorable court, without lawful authority, conspired among yourselves and dealt in 500 grams of suspected cannabis sativa, substance similar to cocaine, heroin, and LSD, and thereby committed an offense contrary to and punishable under Section 11C of the NDLEA Act. Tuhuma ta biyu, kai Abdulhamid Yahaya cewa ranar 6 ga watan Satumba da ya gabata a unguwar nan na yi nawa a wajen tashar Mas an haɗa kun an same ku da haɗin baki. Yes, my lord. The first defendant understood the second count, my lord.
The first defendant, let him.
Yes.
Do you understand the charge? Let him speak up and hear him.
He understood.
Since you said you understand the charge, how are you pleading to the said charge?
He pleaded not guilty to the second. He pleaded not guilty to the second count.
The second defendant, do you understand the charge just read out to you?
Aisha Aibu Kawuwa, ka fahimci tuhuma na biyu da ake maka? Ka daga murya. The second defendant equally understood the second count, my lord.
You to tell me, I'm looking at him. I want him to talk to me. Let him look at the camera and talk. Yes.
Yes,
Do you
understand the second count?
I think he understands the count. How is he pleading?
Tunda ka fahimci tuhuma da ake ma, ka aikata ko baka aikata ba. He equally pleaded not guilty to the second count, my lord.
Yes. The charge having been read and interpreted to the defendants from English to Hausa language, they appear to have understood same. Yes.
My lord, since the defendants have pleaded not guilty to the 2 count charges, my lord, we will be asking for a date, my lord, to produce our witness, my lord. My lord, regarded by the court hearing, my lord, any other date is convenient for us, my lord.
Yes, my lord, we have heard the plea of the defendant. My lord, before we took a date subject to your convenience, we equally file an application for bail in respect of the defendant. My lord, may wish to take subject to your convenience.
Okay. Go ahead. Any response from the prosecuting counsel? Okay, go ahead.
My lord. My lord, the applicant's application is dated and on the 27th day of October 2022. And is brought pursuant to section 118 and 165 of the Administration of Criminal Justice Law, Act 2015, my lord. My lord, to save the precious time of this honorable court, we are seeking for the following two reliefs. As rightly indicated, first of the motion paper.
Yes.
My lord, we are seeking for the relief of this honorable court to admit the applicant bail, finally determination of the charges leveled against them. And the second prayer is an omnibus order. And for such order as this, my lord, I do feel to make it the circumstances. My lord, due to the network problem and my learned colleague who is not opposing the application, we have accompanied a 9-paragraph affidavit in support with one annexure marked as Exhibit A, titled "The Copy of the Charge Sheet," and a written address in support. And Lord, bail is a discretionary powers of my lord. We urge her lordship to consider our application for the interest of justice. This is our humble application, and we so submit. May it please the court. Thank you, my lord.
Counsel. The challenge I have putting the applicant's name in, the applicant is still before this on of being in possession of narcotics. And the same thing here, he is similar charges. ruling.
As court pleases.
The defendants, Hamid Yahya, were arraigned before this honorable court on a two-count indictment contained in a charge dated 7th and filed 2022, and their plea taken today, 28th day of October 2020. The defendants pleaded not guilty to the two-count charge, and their counsel, DI, introduced the defendant's pending motion on notice dated 27th October 2022 and filed the same date. The prayers is for an order of this honorable court admitting the applicants on bail pending the final determination of the charges leveled against them. The defendant's motion on notice is supported by a 9-paragraph affidavit deposed to by one Abdullahi Ibrahim Gambo, a litigation staff in the law office of the defendant's counsel. The applicant defendant counsel, Ndahi Esquire, filed a written address to argue the defendant's motion on notice and set down a sole issue for determination, which is whether the applicants are entitled to the relief sought. Counsel answered his causa in the positive and argued that the applicants are entitled to the presumption of innocence and cited a couple of cases in support. This honorable court, having perused the processes filed by the applicant defendant counsel, comprising of the motion, motion paper, affidavit in support, and written address, observe that the prosecuting counsel did not file any affidavit as a counter. The grant of bail is not one that is to be attended to mechanically or myopically without due consideration of the facts as presented in the application. The grant of bail is at the discretion of the court, and this is a fact born out of the communal reading of the provisions of sections 158 to 163 and 165 and 167, sub 1 of the Administration of Criminal Justice Act 2015. The court is entitled in the exercise of its inherent jurisdiction as prescribed by section 66A and B of the Constitution of the Federal Republic of Nigeria to make judicial orders from the recognized and prescribed legal consequences of occasions when it arises, as in this and as it is in this instance. This honorable court in matters, haven't taken into account that in matters of bail pending trial, there's some evidence that may not be admissible as evidence in the main trial, but they are certainly worthy to be taken into account in an application for bail pending trial. Siba Mayi versus State, Abacha versus State, AU versus State, Antata versus IGP, Abiola versus Federal Republic of Nigeria, etc. Again, it is not automatic that once the charge is an indictable felony punishable as in this instance with a term of imprisonment, that bail will be granted. Whilst the jurisdiction the court exercises in bail applications is required to be so exercised liberally in order to give effect to the provisions and spirit of the Constitution, In particular, is Section 36, sub 5, by which a defendant is presumed innocent until the contrary is established. The court is often concerned with one major issue in the guidelines. It is the prospect of the defendant returning to the court to face his trial, where the hope is dim and there are no materials placed before the court to assuage the fear of the state that the defendant will be available to face his trial. The court in deserving cases, even for such indictments as in this case, will ex debito justitiae refuse to exercise its discretion in granting bail. The fundamental issue in all of this is the prospect that the defendant will be available to attend his trial whilst on bail. This, in my view, the fluid nature of the jurisdiction that a court of first instance, whilst exercising its judicial powers on bail, which on the authorities it is required to exercise judicially and judiciously, should never find itself boxed, as it were, into a corner, and thereby become inhibited in considering any application which may be made to it in furtherance of its quest for justice, because the overall objective and goal of the court is to accord both the parties a fair hearing and the defendant a fair trial. This court, taking the interest of the applicant defendants as well as the larger society's interest, which has a stake in every decision, the court must be alive to its environment, especially as it relates to the upsurge of violence vis-a-vis the prevalence of illegal possession of narcotics by the citizenry in the system, and also possession of arms. The Nigerian state is undergoing serious security challenges. To a large extent, the proliferation of narcotics are among the contributory factors we as a society are presently facing, especially when viewed through the prism of the security challenges bedeviling Yobe State. There is no court of law having regard to the provisions of Section 122 of the Evidence Act 2011, by which courts can take judicial notice of certain notorious facts, can shut its eyes to these incidents, as it will be an act of sheer judicial affectation to pretend all is well. As I stated earlier, before started reading this judgment, this defendant is in a sister case granted bail on a similar charge. And I am aware of the principle that where a particular type of offense has become prevalent in an area where an application for bail is being taken, the court must be alive to its environment without prejudging any issue or denying the defendant their undoubted fundamental right to presumption of innocence in weighing the need to exercise its discretion one way or the other. While the defendant is not being prejudged as a commercial dealer, the unrelenting orgy of violence and killings which the usage of such narcotics wreaked on a hapless nation and a defenseless and innocent citizenry, including kidnappings of people in the states and neighboring states, as well as killings, wherein people in villages while on transit are being kidnapped, examples of incidents which no court of law can afford to ignore and treat it as extraneous materials which need not be reflected upon while considering the applicant's motion or notice for bail. It is not that these incidents are to be used to deny bail to the defendant, but this court will fall short of being a court of law and justice if it pretends that all is well in the polity in terms of security of lives and properties, which in the last few years have come under relentless and mindless onslaughts, allegedly by people who ingest such drugs or narcotics. As I stated earlier, the main function of bail is to ensure the presence of the defendants at the trial. This criterion is regarded as not only the omnibus one, but also the most important of all criteria for granting bail. Whilst the court is concerned that the presumption of innocence of the defendants, which is constitutionally granted, is protected, it must also ensure that the capacity of the state to enforce its criminal legislations against the defendants is not undermined by a casual approach to the grant of bail, which invariably may encourage persons standing trial to take advantage of the softness of the court to abscond, as it's happening in this present case. Once this happens so frequently, the capacity of the state to enforce its criminal legislations will be gravely undermined, and this itself becomes a major security. The court is therefore required not only to do so judicially, but by adverting its close attention, materials placed before it. Whilst I agree that the issue of admitting or not admitting charge raised may not be a grant bail pending trial, it is my view that the defendant on their part have not provided sufficient material by which this court can come to a decision that the defendants are entitled to a favorable exercise of this court's discretion. In common law or commonwealth jurisdiction, is the prospect that the defendant will be applied to face his trial as one of the judicial rights laid down by the apex court in a plethora of decisions that will determine the success or otherwise for an application as was filed by the defendant in the instant matter. Let me again state that I am not in doubt that the offense alleged in the charge is a bailable offense, notwithstanding the seriousness of the offense and the severity of the punishment prescribed by law, and a refusal of bail does not remove the constitutional presumption of innocence in favor of a defendant. When all of these issues are taken together, I'm constrained and found it rather difficult to exercise my judicial discretion in favor of granting bail to the applicant. Defendant, considering the analysis I had done of this ruling. Consequently, the application for bail filed and argued on behalf of the defendants, applicants, is hereby refused for the reasons are given in this ruling. Instead of granting I'll grant accelerated trial of the charge against the defendant. If my intention
Let's go, please.
within the space available in the court diary to accord this case accelerated hearing, and counsel may take as many as 3 different dates. I'd like to hear counsel as regards when the trial of the defendant
Let's go, please.
this shall be the ruling of the court on the said application is accordingly refused.
As the court pleases. A takaice, lauyan ku ya nemi a bada beli, amma duba da wasu hujjoji da kuma dalilai wanda mai shari'a ta gabatar, wanda kaɗan daga ciki hujjojin da ya hana a bada beli ku shine kai Abdulhamid kana da makamancin shari'a yanzu haka a kotu wanda ya shafi kayan wuri, kuma gashi ka sake aikata irin wannan laifi aka kama ka ciki. A taƙaice kenan da wasu hujjoji da ta faɗa, wannan yana daga cikin dalilin da ya sa kotu take ba da beli. Sannan kotu za ta fara shauraron wannan shari'a naku ba sassautawa. Lauyan ku zai iya zaɓen kwanaki a jere 2 zuwa 3 hakan bai ta yin wannan shari'a naku saboda sassauta a yi shi da wuri, tunda ba ba da beli ba. A taƙaice kenan.
Yes.
We are much grateful, my Lord. My Lord, I don't know the convenience of the prosecution's diary. If convenience, 3rd of November is convenient.
Give us a date. 3 clear days. For 3 clear days, 3rd November is going to be suitable. But do you prefer just a single day?
November is congested. We have about 5 days, and most of them are preparing.
I can't hear you.
My Lord, I said 3rd November is congested with a lot of cases, about 5 cases are called for hearing.
Which are generally any no. Prosecuting counsel, how about
Pardon, my Lord.
16th? November 16th.
My Lord, 16 also, my Lord. But we can accommodate it. Yeah, 3 cases.
All trial.
Hello, I couldn't hear the date, sorry. My network went off, I came back.
They're trying to gain because all the days are.
November?
We are yet to decide on a date.
All right.
Yeah. This case, can you hear me? Is hereby adjourned to 10th day for commencement of trial. While the defendants are to be remanded at the Portisco Correctional Center till the next adjourned date.
Asco, please, my lord.
10th, 1-0.
Asco, please.
10th of November
Yes.
is convenient.
Okay. Then call the next case.
As the court pleases. Catch number FSC/DM/PR/20/55/2022 between Federal Republic of Nigeria versus Zubairu Ibrahim. Yes, my lord. The defendant is present with us here at the Correctional Center, Portisco. And he speaks Hausa, my lord.
Respectfully, my lord.
My name is Muhammad,
And my full appearance.
With humility and respect, my lord, and DR Ibrahim for the defendant.
My lord, the matter I selected today for mention and subject to the convenience of my lord, we are ready to proceed.
We are equally ready, my lord.
Let's go ahead. Yes.
my lord.
My lord, the complaint a 2-count charges against the charge is dated October and filed the 18th day of October. My lord, we apply for understanding of the. Thank you, my lord.
Okay. Right. Mustafa, go ahead.
God please. Zubairu, zan karanta tuhuma da ake masa turancin fassara ta Hausa. Inda karanta ka kalli wannan waya. Count 1. That you, Zubairu Ibrahim, male adult of Ngambi Town, Kaga local government area of Borno State, on 20th day of September 2022, during raid operation by NDLEA officers at Kukareta Market, Yobe State, within the jurisdiction of this honorable court, without local authority, he possessed 2.5 kilograms of dried wheat suspected to be cannabis sativa, a substance similar to cocaine, heroin, and LSD, and thereby committed an offense contrary to and punishable under Section 19 of the NDLEA Act. Zan fassara mata Hausa cewa kai Zubairu Ibrahim da ke garin Gamdu a ƙaramar hukumar Kaga ta jihar Borno a ranar 20 ga watan Satumba na shekarar nan da muke ciki. Wayannan ma'aikata na masu hana sha da safara da miyagun ƙwayoyi ta ƙasa wato NDLEA a kasuwar Kukareta da ke jihar Yobe sun kama ka da mallakar kilogram 2.5 na busasshen ganye wanda ake zargin tabar wiwi ce, wanda hakan ya saba ma sashi doka na 19 na wannan hukuma. Ka ji tuhuma da ake maka na farko?
You understand?
Ka fahimta?
Since you said you understand, take charge.
As the court please. Ka aikata ba ko ba ka aikata ba? Madam, the defendant pleaded not guilty to the first count charge.
Yes, read out the second charge.
As the court pleases, zan karanta ma tuhuma ta biyu. That you, Zubairu Ibrahim, male adult of Gambi Town, Kaga local government area, Yobe, Borno State, on the 20th day of September 2022, during raid operation by NDLEA officers at Kukareta Market, Yobe State,
within the jurisdiction of this honorable court without local authority, you possess 8 grams of tramadol and 1 gram of diazepam suspected to be psychotropic substances. A substances similar to cocaine, heroin, and LSD, and thereby committed an offense contrary to and punishable under Section 19 of the NDLEA Act. Tuhuma ta biyu, cewa kai Zubairu Ibrahim da ke garin Gamdu, ƙaramar hukumar Kaga da ke jihar Borno. A ranar 20 ga watan Satumba na shekarar nan da muke ciki a kasuwar Kukareta da ke jihar Yobe. An kama ka da mallakan gram 8 na tramadol da kuma gram 1 na diazepam, wanda waɗannan ƙwayoyi ne masu haukatarwa, masu kama da cocaine da LSD. Saboda haka ka saba ma sashin doka na 19 na hukumar nan masu hana sha da safara da miyagun ƙwayoyi ta ƙasa. Ka fahimci tuhuma ta biyu?
Up to you.
Equally under the second count, my lord.
Since you said you understand the charge,
Aikata ko baka aikata ba wannan tuhuma ta biyu. Equally pleaded not guilty to the second count, my lord.
yes.
Yes. And since the defendants have pleaded not guilty to the first and second count charge, my lord, we shall be applying for a date, my lord, to produce our witness.
Yes, my lord. Thank you for the audience. Before we took date, my lord, we are seeking the convenience of my lord to admit us to give us audience for application for bail, security and convenience.
Yes. Go ahead.
Thank you. My lord, the applicant's application is dated and filed on the 20th day of October 2022, respectively. Broad portions to sections 158 and 16. As well as under the inherent powers of our lordship. My lord, we are seeking for 2 reliefs, as rightly indicated on the motion paper. An order of this honorable court admitting the applicant on bail, level against as this honorable court might deem fit to make in circumstances. We have accompanied a 9-paragraph affidavit in support with 1 annexure, as well as a written address. My lord, sorry for the network issues. That's why I'm taking it as it is. My lord, we are urging this honorable court not to that.
I can't hear counsel any longer. It's frozen on the screen. The sender here, square.
Urge my lord to grant our application. We are very much sorry for this network issue. Thank you so much.
Thank you. Ruling. The African Defendant Council applied for bail of the applicant and notice application. This honorable court haven't listened to the application. The prosecution is not challenging the application. This honorable court haven't listened to the application and adumbration of line of counsel to the applicant. And after perusing the motion for bail with attached processes, hereby grant the application on the following conditions. One,
As copies.
sum of 3 million naira and 2 sureties in the like sum. Two, the first surety must be a traditional or religious leader in Yobe State. Three, the second surety must be a responsible member of the society from any sector. Four, the two sureties to stand for the defendant must be resident in any of the local government capitals of Yobe State. And that fact must be verified by the NDLEA as reliable. Five, the two sureties shall each swear to an affidavit of means. Can you hear me? It's gone. Counsel, can you hear me?
My lord, we are much grateful. Yes, we can hear you now. We are much grateful and obliged with this sound ruling. May it please the court.
Because I've not complete, I have like 8 conditions. Then number 6, the defendant applicant together with both sureties. Can you hear me? It seems they're having.
I can hear you.
Oh, I see. Must each deposit 2 copies of their recent passport photographs with the station registrar of this court. 7, the defense counsel shall write a formal letter to the station registrar, Federal High Court Damaturu, to introduce the respective sureties as responsible citizens.
As
To whom the
please.
can safely release the defendant on bail pending his trial. 8, the defendant is to provide a valid active bank account attached to a BVN number. This fact must be verified by the defendant counsel as having been complied with before the release of the applicant on bail. The application succeeds on the terms, conditions as prescribed. Meanwhile, the defendant is to be remanded in Potiskum Correctional Center until he fulfills the bail conditions. The matter is hereby adjourned to give me a date. 24th. This matter is hereby adjourned to the 24th day of January 2023 for commencement of hearing. I think we have lost them. Challenges of virtual.
We are much obliged, my lord. Thank you so much for the sound ruling.
Thank you so much, counsel, and I apologize for the network issues.
Yes, we are having serious network issues. No.
It is called the next case. Madam Mustafa, can you unmute your device?
Yes, ma'am.
Okay. Please, can you call the next case?
Yes, my lord. As the court pleases. Charge number FSC/DM/CR/T/2020. Federal Republic of Nigeria by Lady Isa Mohammed.
Which case did you just?
Isa Mohammed, CR60. Isa Mohammed.
Yes.
Yes, my lord. We are together with the defendants at the correctional center here in Portisco, and he speaks Hausa language, my lord.
Okay.
Thank you.
The presentation, please.
Please, my lord. My name is Usman Bamara, and my humble appearance is for the complainant.
Yes.
With respect and humility to our lordship. I'm D.I. Indahi. My humble appearance is for the defendant before the court.
My lord, the matter is selected to the information and subject to the convenience of my lord. I am ready to proceed, my lord.
Yes. Go ahead.
My lord, we are equally ready as well.
My lord, the complainant has filed a single count charge against the defendant, my lord. The charge is dated on the 25th day of October 2022 and filed on the 26th day of October 2022. My lord, we apply for the content of the charge to be read to the understanding of the defendant. Thank you, my lord.
Yes. Go ahead.
As the court pleases. Isa Mohammed, zan karanta tuhuma da ake maka da turanci na fassara maka da Hausa. Charge that you, Isa Mohammed, adult of Masallacin Idi area, Buniyadi, Kujiba local government area, Yobe State, on 11th day of October 2022, in the course of raid operations along Buniyadi Road, Yobe State, within the jurisdiction of this honorable court, without local authority, you possess 48 kilograms of dried weed suspected to be cannabis sativa, a substance similar to cocaine, heroin, and LSD, and thereby committed an offense contrary to and punishable under Section 19 of the NDLEA Act. Zan fassara maka. Cewa kai Isa Mohammed da ke unguwar masallacin Idi da ke garin Buniyadi a ƙaramar hukumar Gujiba da ke jihar Yobe. A ranar 11 ga watan 10 na shekarar nan da muke ciki, a lokacin da wayannan wato ma'aikatan nan na masu hana sha da safara da miyagun ƙwayoyi wato NDLEA suka kai su mane a garin Buniyadi da ke nan jihar Yobe, an kama ka da mallakan kilogram 48 na busasshen ganye wanda ake zargin tabar wiwi ce, wanda hakan ya saba ma sashi doka na 19 na masu hukumar nan na masu hana sha da safara da miyagun ƙwayoyi ta ƙasa. Ka fahimci tuhuma da ake maka? Although the defendant has understood the content of the charge.
How I plead into the same charge.
Ka fahimta, ka aikata ko ba ka aikata ba. Although he pleaded not guilty to the content of the charge. Ka daga murya a ji. He pleaded not guilty.
Yes.
Since the defendant has pleaded not guilty to the content of the charge, my lord, we shall be applying for a judge, my lord, to produce our witnesses, my lord.
My lord, the applicant, subsequent to his plea, my lord, will usually file an application for his bail. Subject to your convenience, we are ready to accept.
Go ahead, counsel.
Thank you, my lord. My lord, the applicant's application is dated and filed on the 27th day of October 2022, respectively. Brought pursuant to sections 158 and 165 of the Administration of Criminal Justice Act 2015 and under the inherent powers and jurisdiction of this honorable court. My lord, we are praying for an order of this honorable court admitting the applicant on bail pending the final determination of the charge level against him, and an omnibus order as this honorable court might deem fit to make in the circumstances. My lord, in support of the affidavit of 9 paragraphs, we have annexed one annexure marked as Exhibit A, as well as a written address in support. My lord, the respondent having not counter or opposed same, we are urging her lordship to exercise her discretion in favor of the applicant for the interest of justice. My lord, this is our humble application. May it please the court. Thank you.
Ruling. The applicant defendant counsel applied for bail of the applicant defendants and moved his application on terms. The prosecuting respondent counsel is not challenging the application. This honorable court, having listened to the application and adumbration of the learned counsel to the applicant defendant, and after perusing the motion for bail with attached processes, hereby grant the application on the following conditions. 1, in the sum of 3 million naira and 2 sureties in the like sum. 2, the first surety must be a traditional or religious leader in Yobe State. 3, the second surety must be a responsible member of the society from any sector. 4, the 2 sureties stand for the defendant must be resident in any of the local government capitals of Yobe State, and that fact must be verified by the NDLEA as reliable. 5, the 2 sureties shall each swear to an affidavit of means. 6, the defendant applicant together with both sureties must each deposit 2 copies of their recent passport photographs with the station registrar of this court. 7, the defense counsel shall write a formal letter to the station registrar, Federal High Court Damaturu, to introduce the respective sureties as responsible citizens to whom the court can safely release the defendant on bail pending his trial. 8, the defendant is to provide a valid active bank account attached to a BVN number. This fact must be verified by the defendant counsel as having been complied with before the release of the applicant on bail. The application succeeds on the terms and conditions as prescribed. Meanwhile, the defendant is to be remanded in Fortiskum Correctional Center until he fulfills the bail conditions. The matter is hereby adjourned to the 24th day of January, 2023. And then you have muted yourself. Your phone is on mute. And then he
10 January.
1st January.
Fourth. As what pleases. Well, we are much grateful with the sound we made. Please, the court.
Thank you.
My lord, sorry to ask, my lord, the subsequent one is also fourth. Where Ibrahim?
Okay, the earlier case.
Yes, where Ibrahim is also fourth.
24th. 2-4.
As what pleases.
24 January.
All right, my lord. We are much grateful.
Mustafa, call the next case.
As the court pleases. Charge
My lord,
number
we'll take our leave. That's all what I have before you. Thank you.
Okay, thank you.
Charge number SSC/GM/CR/.
Yes, that's all I have, my lord. Thank you for today.
Between the Federal
Thank you.
Republic of Nigeria.
Listen, then you need to mute your gadget. Thank you so much.
Samaila Sani and Mohammed Ibrahim.
Mustafa, which case did you call?
Samaila Sani, my lord. Case number 1 at the list.
Okay.
Samaila Sani. The Ibrahim Mohammed Ibrahim Mohammed. Samaila Sani. Yes, my lord. Samaila Sani ne zamu. Respectfully, my lord, my name is Usman Bamana and my humble appearance is for the complainant. Yes, my lord, the defendant has no legal representation. My lord, the complainant have filed two count charges against the defendant. My lord, the charge is dated on the 16th day of August
2022 and 5 October 2022. My lord, we apply for
Mustafa, ask him if he has a lawyer.
As the court pleases. Canada lawyer. What lawyer? He has no
Do you
legal
want time
representation.
to enable you procure the services of a
As the court pleases. Kana so a baka lokaci ne ka nemi lawyer da zai wakilce ka a wannan shari'a naka?
or are you ready to proceed?
A shirye kake kawai kotu ta ci gaba da shari'a. My lord, he said that let the court proceed with the matter.
Okay, these are the charges against.
As the court pleases. Zan karanta an fassara ma hukuma da ake maka. Count 1, that you, Samaila Sani, male adult of Bakori local government area of Katsina State on 10th day of July 2022 at NDLEA stop and search operations along Damaturu Potiskum Road, Damaturu, Yobe State, within the jurisdiction of this honorable court, without local authority you possess 21.5 kilograms of dried weed suspected to be cannabis sativa, a substance similar to cocaine, heroin, and LSD, and thereby committed an offense contrary to and punishable under Section 19 of the NDLEA Act. Zan fassara tuhuma da ake ma na farko. Cewa kai Sama'ila Sani da ke karamar hukumar Bakori da ke jihar Katsina a ranar 10 ga watan 7 na shekarar nan da muke a shingen nan na bazin binciken a shingen nan na hukumar na masu hana sha da safara da miyagun ƙwayoyi wanda suke binciken ababen hawa daga kan hanyar da masu zuwa Fatisco a nan jihar Yobe. Ba tare da hukuma ta baka izini ba, an same ka da mallakan kilogram 21.5 na busasshen ganye wanda ake zargin tabar wiwi ce, wanda hakan ya saba ma sashin doka na 19 na hukumar na masu hana sha da safara da miyagun ƙwayoyi ta ƙasa. Ka fahimci tuhuma da ake ma? Na fahimta. My lord, the defendant has understood the first count, right, and explained to him the outcome. As the court pleases. Ka fahimta ba? Na fahimta. Ka aikata ko ba ka aikata ba? Ka aikata? My lord, he pleaded guilty to the first count charge.
Read the second.
As the court pleases. Count 2, that you, Sama'ila Sani, adult of Bakori local government area, Katsina State, on 10th day of July 2022, at NDLEA stop and search operations along Damaturu Potiskum Road, Damaturu, Yobe State, within the jurisdiction of this honorable court, without local authority, dealt in 21.5 kilograms of suspected cannabis sativa, similar to cocaine, heroin, and LSD, and thereby committed an offense contrary to and punishable under Section 11 of the National Drug Law Enforcement Agency Act, N30, Laws of the Federation 2004 amended. Hukuma ta biyu da ake maka, kai Sama'ila, da ke ƙaramar hukumar Bakori na jihar Katsina, a ranar 10 ga watan 7 na shekarar nan da muke ciki, an same ka kana ta'ammali da kilogram 21.5 na busasshen ganye wanda ake zargin tabar wiwi ce, wanda hakan ya saba ma sashin doka na 11 na hukumar na masu hana sha da safara da miyagun ƙwayoyi ta ƙasa. Ka fahimci wannan tuhuma ta biyu? Na fahimta. Equally understood the
Pleading to the same charge.
As the court pleases. Ka aikata ko ba ka aikata ba? Na aikata. Ka ɗaga murya a ji. Na aikata. My lord, he equally pleaded guilty to the second count of the charge.
Yes.
Yes. My lord, since the defendant has pleaded guilty to the first and second count charges, my lord, we shall be asking for a very short date to reduce part of the case, my lord. My lord, we shall be very, very quick here.
Your application?
My lord,
My lord,
I see that we shall be asking for my lord, we shall be guided.
Give us a okay. Council. Council.
Sorry, my lord.
Is it? Let's see. Diary, I'm using it to prop this system. Let me. I know. Just any date. Give me a date. Yes. Okay. 10th. Okay. This case was called. The defendant is present and pleaded guilty to the 2-count charges against him. The learned prosecutor consequently indicated his intention to conduct a review of the facts of the charge. This is an exercise which is peculiar to drugs and related offenses and was not meant to require the prosecution to prove the allegation in a criminal charge, which the accused person had voluntarily pleaded guilty to. By the provision of the law, except in capital offenses, once an accused person had pleaded guilty to an indictable felony, punishable with a term of imprisonment, the court is empowered, especially in relation to the Federal High Court, who by Section 33 sub 2 of its enabling act F12 laws of the Federation of Nigeria 2004, empowered to try criminal cases and matters summarily, to proceed to convict the defendant. The exercise to do a review of the facts of the charge to which the learned prosecutor applied for an adjournment to the 10th day of November 2022 is granted. Meanwhile, the defendant is to be remanded in the Potiskum Correctional Center to the next adjourned date.
My lord, sorry, my lord. Did you just say 10th?
November.
Okay.
Yes. Malam Mustafa.
Yes, ma'am. An kai shari'an sannan zuwa ranar 10 ga watan. Charge number FSC/DM/CR/58/2022 between the Federal Republic of Nigeria versus Mohammed Umar Ali, aka Bondo. Yes, my lord. The defendant is currently with us here at the Correctional Center, Potiskum, and he speaks Hausa language. He is case number 6 on the list.
Yes.
Respectfully, my lord, my name is AJ Odi, and my humble appearance is for the
Yes.
Yes. My lord, the
complainant have filed 2-count charges against the charge is dated on the 24th day of October 2022 and filed on the 22nd. My lord, we apply for the understanding of the defendant, my lord.
This honorable court having listened to this hereby grants the application.
Let's go.
Read out the
As the court pleases, Mohammed Umar, zan karanta tuhuma da ake maka fassara maka da Hausa. Count 1, that you, Mohammed Umar Ali, aka Bondos, adult of Pomfomari Lotto area, Damaturu, Yobe State, on the 14th day of March 2022, at the cost of raid operation at your warehouse, Halima Rani Ward, Damaturu, Yobe State, within the jurisdiction of this honorable court, without local authority, possessed 209 kilograms of dried wheat suspected to be cannabis sativa at your warehouse situated at Halima Rani Ward, Damaturu, a substance similar to cocaine, heroin, and LSD, and thereby committed an offense contrary to and punishable under Section 19 of the NDLEA Act. Zan fassara ma wannan tuhuma da ake mana farko. Cewa kai Muhammad Umar Ali, wanda aka fi sani da Bondos, da ke unguwar Pomfomari Lotto area da ke Damaturu a nan jihar Yobe, a ranar 14 ga watan uku na shekarar nan da muke ciki. Lokacin da wayannan jami'an hana sha da safara da miyagun kwayoyi suka kai sumane wani inda kake zama a nan almarani kenan da ke nan jihar Yobe, sun kama ka da mallakar kilogram 209 na busasshen ganye wanda ake zargin tabar wiwi ce a nan anguwa da ke almarani kenan a Damaturu, wanda hakan ya saba ma sashin doka na 19 na hukumar masu hana sha da safara da miyagun kwayoyi ta kasa. Ka fahimci tuhuma da ake ma? Yes, madam.
I'm asking him if you understand.
Yes, my lord. He understands the content of the first count of the charge. Check.
How are you pleading?
He pleaded not guilty to the first count, my lord.
Go ahead, read the second.
As the court pleases, that you, Mohammed Umar Ali, aka Bondos, adult of Pomfomari Lotto area, Damaturu, Yobe State, on 10th day of March 2022, at the cost of raid operation at your warehouse, Unukumbu Pawari area of Damaturu, Yobe State, within the jurisdiction of this honorable court, without local authority, possessed 85 kilograms of dried wheat suspected to be cannabis sativa at your warehouse situated at Udukumbu Pawari area, Damaturu, a substance similar to cocaine, heroin, and LSD, and thereby committed an offense contrary to and punishable under Section 19 of the NDLEA Act. Tuhuma ta biyu zan fassara maka. Cewa kai Muhammad Umar Ali, wanda aka fi sani da Bondos, da ke Pomfomari Lotto, unguwar Pomfomari Lotto da ke Damaturu a jihar Yobe. A ranar 10 ga watan uku na shekarar da muke ciki, lokacin da jami'an nan na hana sha da safara da miyagun kwayoyi suka kai sumane a inda kake ajiye kayanka da ke nan unguwar Budukumbu Pawari a Damaturu da ke jihar Yobe, an kama ka da mallakar kilogram 85 na busasshen ganye wanda ake zargin wannan tabar wiwi ce a inda kake ajiye kayanka a wannan anguwa na Budukumbu Pawari da ke Damaturu. Saboda haka ka aikata laifi wanda ya saba ma sashin doka na 19 na hukumar nan masu hana sha da safara da miyagun kwayoyi ta kasa. Ka fahimci tuhuma ta biyu? Yes, madam, you fully understand.
How are you pleading to say?
As the court pleases, ka aikata ko baka aikata ba. He equally pleaded not guilty to the second count, my lord. My lord, since the defendant have pleaded not guilty to the first and second count charge, my lord, we shall be asking for a date for this witness. My lord, we are asking for the 10th day of November 2022, my lord. My lord.
The ruling, the application, prosecuting counsel is hereby granted. Much adjourned. Madam Mustafa,
Hello.
let's call the next case.
As the court pleases. Charge number FSC/GM/CR/56/2022 between the Federal Republic of Nigeria versus Mohammed Ibrahim Mohammed. Yes, my lord, the defendant is currently with us here at the Correctional Center, 42, and he speaks Hausa language, my lord. With the greatest respect and much honor, my lord, my name is Usman Bamala, and my humble appearance is for the complainant. My lord, the defendant is not having legal representation. My lord, the complainant have filed a single count charge against the defendant. The charge is dated on the 16th day of September 2022
And filed
on the 20th day of October 2022.
we apply for the person of the defendant. Thank you.
Madam Mustafa, asking when.
As the court please. As the court please. Baka da lawyer mai kare ka. Kana son kotu ta baka lokaci ka nemi lawyer ko dai kana so kawai kotu ta ci gaba da wannan shari'a.
I cannot hear his answer. Engage services of.
Yes, he said that he wants the court to go ahead with the matter. You don't have to engage counsel.
To proceed with the matter.
Yes, my lord. You want court to proceed with the matter.
Then go ahead without the
As the court pleases, that current tuhuma da ake maka fassara maka. Charge that you, Mohammed Ibrahim Mohammed, adult of Sumsuma area, Damaturu, Yobe State, on 20th day of August 2022 at NDLEA stop and search patrol points along Damaturu Meduguri Road, Damaturu, Yobe State, within the jurisdiction of this honorable court, without local authority, possessed 142 grams of dried weed suspected to be cannabis sativa, substance similar to cocaine, heroin, and LSD, and thereby committed an offense contrary to and punishable under Section 19 of the NDLEA Act. Zan fassara maka ta Hausa cewa kai Muhammad Ibrahim Muhammad da ke unguwar Suntumma da ke Damaturu a nan jihar Yobe. A ranar 20 ga watan Agusta na wannan shekara da muke ciki, a shingen nan wanda wannan hukumar masu hana sha da suke kuma masu hana sha da safara da miyagun kwayoyi a nan inda suke shingen binciken ababen hawa da ke kan hanyar Damaturu zuwa Maiduguri da ke garin Damaturu a jihar Yobe sun kama ka da mallakan gram 142 na busasshen ganye wanda ake zargin tabar wiwi ce, wanda wannan ya saba ma sashi 19 na hukumar masu hana sha da safara da miyagun kwayoyi ta ƙasa. Ka fahimci tuhuma da ake maka? Ka daga murya a ji, ka fahimci. He understood the content of the charge.
Since you understand the charge, you're not guilty to the said charge.
As the court pleases, kasancewar ka fahimta, ka aikata ko baka aikata laifin da ake zargin ka da shi ba, a aikata. My lord, he pleaded guilty to the one count charge, my lord. My lord, the defendant
have pleaded guilty to the second count charge. My lord, I shall be asking for it to review the facts of the case.
To which date?
My lord, 10. My lord, we shall be asking for the 10th day of November 2023. My lord.
Ruling. This case, defendant is in court and pleaded guilty. Charge against him, the learned prosecution stated his intention. Conducts a review of the facts of the charge. This was an exercise which is peculiar to drugs and related offenses, and was not meant to require the prosecution to prove the allegation in a criminal charge, which the defendant had voluntarily pleaded guilty to by the provision of the law, except in capital offenses. Once an accused person has pleaded guilty to an indictable felony, punishable with a term of imprisonment, the court is empowered, especially in relation to the federal high, who by Section 33 sub 2 of its Enabling Act, Cap F12, laws of the Federation of Nigeria, 2004, empowered to try criminal cases and matters summarily, proceed to convict the defendant, the exercise to do a review of the facts of the charge, which the learned prosecutor applied for an adjournment to the 10th day of November 2020 is granted. Meanwhile, the defendant is to be remanded in the till the next adjourned date.
An daga wannan shari'a naka zuwa ranar 10 ga watan 12 da za mu shiga. Ranar ne za a ci gaba a yanke maka inda ka amsa laifin ka zo na.
Yes, almost.
As the court please. Charge number FSC/DM/CR/57/2022 between the Federal Republic of Nigeria versus Ali Mohammed. Yes, my lord, the defendant is currently with us at the Correctional Center, Portisco, and he speaks Hausa language, my lord. With the greatest respect and much honor, my lord, my appearance is for the complainant. My lord, the complainant has filed 2 count charges against the defendant. The charge is dated on the 16th day of August 2022 and filed on the 20th day of October 2022. My lord, we apply for the content of the charge to be read on the side of the defendant. The purpose of taking his speech. As the court pleases.
Defendant has no legal representation
As the court pleases.
time to be given to engage a counsel. Proceed with the trial.
As the court pleases. Ali Mohammed, baka da lawyer ba? Ka daga murya ka kalli. Kana bukatan kotu ta baka lokaci ka dauki lawyer ko dai baka bukatan haka kawai a fara shari'a. My lord, he said that he is not willing to engage the services of a counsel. He wants this court to proceed with the matter.
Okay, go ahead and read the.
As the court pleases, one karanta tuhuma da ake masa guda biyu. Charge, count 1, that you, Ali Mohammed, adult of Madiganari Ward, Maiduguri, Borno State, on 10th day of July 2022, at NDLEA stop and search operation along Damaturu, Portisco Road, Damaturu, Yobe State, within the jurisdiction of this honorable court without local authority, you possess 20 kilograms of dried weed suspected to be cannabis sativa, substance similar to cocaine, heroin, and LSD, and thereby committed an offense contrary to and punishable under Section 19 of the NDLEA Act. Zan fassara mata Hausa tuhuma da ake mana farko. Cewa kai Ali Mohammed da ke anguwar Madiganari da ke Maiduguri a jihar Borno a ranar 10 ga watan 7 na shekarar nan da muke a shingen da ake binciken ababen hawa na hukumar na masu hana sha da safara da miyagun kwayoyi da ke kan hanyar Damaturu zuwa Portisco da ke Damaturu a nan jihar Yobe. Ba tare da hukuma ta baka izini ba, an kama ka da mallakan kilogram 20 na busasshen ganye, wanda wannan ake zargin tabar wiwi ce, wanda hakan ya saba ma sashi 19 na dokar nan na hukumar hana sha da safara da miyagun kwayoyi ta kasa. Ka fahimci tuhuma da ake ma na daya? Ka daga murya. Kasancewar ka fahimta, ka aikata ko ba ka aikata ba. My lord, he pleaded guilty to the first count charge.
Can you read out the second?
As the court pleases. Zan karanta ma tuhuma ta biyu. Count 2. That you, Ali Mohammed, adult of Modiganari Ward, Maiduguri, Borno State, on 10th day of July 2022 at NDLEA stop and search operation along Damaturu Podistum Road, Damaturu, Yobe State, within the jurisdiction of this honorable court without local authority, dealt in 20 kilograms of suspected cannabis sativa, a substance similar to cocaine, heroin, and LSD, and thereby committed an offense contrary to and punishable under Section 11 of the NDLEA Act. Tuhuma ta biyu cewa kai Ali Mohammed da ke unguwar Madaganari a Maiduguri, jihar Borno, a ranar 10 ga watan 7 na shekarar da muke ciki, inda ake binciken ababen hawa a kan hanyar Damaturu zuwa Potiskum da ke nan Damaturu a jihar Yobe. Ba tare da hukuma ta baka izini ba, an kama ka da mallakar an kama ka kana ta'ammali da kilogram 20 na busasshen ganye wanda ake zargin tabar wiwi ce, wanda hakan ya saba ma sashi doka na 11 na hukumar nan masu hana sha da safara da miyagun kwayoyi da ƙasa. Ka fahimci tuhuma ta biyu? Inda ka fahimta ka aikata ko ba ka aikata ba. He equally pleaded guilty to the second count, my lord.
Let him speak.
Guilty to the second count. Daga murya a jika.
Yes.
Yes, since the defendant has pleaded guilty to the first and second count charge, we shall be asking for the 10th day of November 2022 for the purpose of reviewing the public case, madam. Thank you.
The question of prosecution matter adjourned to the 10th day for review of facts. Defendant is correctional
And that is around coming to our
a minute. Prosecuting counsel.
My lord.
I noticed that the same name.
Sorry, my lord, I didn't hear you.
The name of the defendant is Ali Mohammed.
Yes,
And we have two other cases with similar names.
Yes, my lord.
So
And the
you,
other, and one of the two that we had before is having the same safety with this one, my lord.
is having
The same way with this one in particular, my lord.
okay, you mean the name and substance in their found in their possession?
Yes, my lord.
Yes, my
The
lord.
only difference is the case number, charge number.
Okay, my lord.
So we to differentiate so that attorneys, they don't bring my
lord, among the three animals, only this particular one so I think we will have, my lord.
You said among the three?
Among the three Ali Mohammed we have, only this one in particular. So I don't know.
Okay, okay, no problem.
Thank you, my lord.
Call the next.
Record please. Charge number SSC/GM/CR/42/2022 between the Federal Republic of Nigeria versus Alhaji Abdullahi.
Madam Mustafa,
Yes, my lord.
the last case.
Yes, the last case, my lord, for review of facts.
Yes, representation.
Respectfully, my lord, my name is Muhammad and I'm humble appearance.
My lord,
The matter
Yes, counsel, go ahead.
Thank you, my lord.
My lord, in person of my lord, can I apply? My lord.
It's not very clear. Your submission.
My lord, I said I have my lord, as the exhibit officer to review.
Okay. Let's go ahead.
Yes, my lord, CW1 in respect of this case is with us here at the Correctional Center, and he is ready to be affirmed, my lord.
Okay. Go ahead.
If I say I, then you can mention your name. I, Mohammed Ravi Sulaiman, do solemnly affirm, he said that the evidence I shall give in this court, in this case, shall be the truth, the whole truth, and nothing but the truth, So help me God, My lord, PW1 has been affirmed. He is male, adult, and Muslim. My name is Mohammed Ravi Sulaiman.
What do you do for a living?
Counsel, let him sit if he wants to.
Thank you, my lord. My name is Mohammed Ravi Sulaiman. I'm working with National Bureau of Law Enforcement.
For how long have you been working?
For almost a year now.
Please, for all this yeah, that you have been working with, what are your
receiving the suspect and the exhibits recovered from them.
Yes, continue.
Carrying out a field test on the exhibits recovered from them. issuing of forms to the defendant, to the suspect, to comprehend, packing of the exhibit into A1 and A3, keeping entry of the book of the exhibit into the exhibit room for safekeeping.
Yes.
Taking the A1 that was instilled in white evidence correspondence coach to Lagos for forensic analysis.
Continue.
Testifying and giving evidence in court with regard to the exhibit handled by me or kept under my custody, and any other adult duty given to me by my superior. Thank you, Mother. Thank you very much.
Take a good look at Tell this honorable court.
Yes, I know.
Tell this honorable court what circumstance.
On the 19th of May, 2022, the defendant was brought before me
Yes.
by that bandit PSM and Nejedu Haruna CNA.
And who?
Nejedu Haruna CNA.
Yes.
Along with the defendant and some tablets that was concealed inside his pocket. I asked the defendant who owns this tablet.
Yes.
And he said it belongs to him. And I told him that I want to carry a field test on the tablet. And he said yes, that I should go ahead. I carry out the test, and the test proved positive for psychoactive tramadol tablet. After the test, I weighed the tablet, that tramadol tablet, and it weighed 23 grams. I issued some forms, namely certificate of test analysis, packing of substance form, request for scientific aid. For the defendant to comprehend, arresting and witnessing officers also to fill their column. After that, I took some parts of the tramadol tablet and seal it inside a white evidence transparent pouch for forensic, and the remaining bulk of the exhibit, that's A3, I kept them inside inside an exhibit room for safekeeping. On the 1st of August, 2022.
On the, is it 1 or 4?
1 or 4. First, 1.
Yes.
Yes, I took the A1 to Lagos for forensic analysis.
Yes.
And on the same day, I received a rainfall. Calling my attention, Mohammed Ravi Suleiman, OC, Exhibit Officer, NDLEA, Yobe State Command. Attached with the brown envelope is result for the forensic analysis and request for scientific aid form. That's all, my lord. Thank you very much, Mr. Ravi Suleiman.
In the course of your testimony, you mentioned that
you said some exhibit form
defendant. More so,
Yes, my lord.
Yes, my lord. Response. Analysis report. Will you be able to?
Yes, my lord.
On the ground, and on the
fighting of substance of certificate of case analysis, my name, my signature was also there, and the date of the documentation.
apply to show the witness with the rest
Yes, my lord, there's one.
My lord, we equally apply for the
Application granted.
Okay.
My lord, this is the remnant of the tramadol capsule that was being analyzed by forensic experts at Lagos. Thank you very much.
My lord, how many we of the test analysis for scientific aid, analysis report, white exhibit.
The following exhibit forms are admitted into evidence. Certificate of test analysis form, NDLEA Alhaji Abdullahi 1. The packing of substance form as PLEA Alhaji Abdullahi. Request for scientific aid form, hereby marked as NDLEA. While the drug analysis is Alhaji Abdullahi 2. The white transparent evidence with the remnants of the tramadol as Alhaji Abdullahi 2B, and the brown envelope as Alhaji Abdullahi 2, respectively.
Scott, please. Thank you, my lord. Mr. Rabiu Suleiman, the course of your testimony before this honorable made mention of the work of exhibits. Is it before this honorable? My lord, we apply for the
application granted.
My lord, we equally apply for the white envelope, my lord, to secure the content.
Go ahead. Malam Mustafa, you have not been interpreting.
Yes, my lord. I want after all that I will summarize and interpret to him.
Okay.
Yes, my lord. Yes, my lord. This is the remnant of the tramadol that was found in possession of the defendant. And in the white paper, the name of the defendant is written there. The NDLEA case file number was also written there, and the date of the commutation.
What is the name? The
NDLEA stroke YBSC stroke 040
0
040
046 40.
Yes, my lord.
Okay.
My lord, since the defendant have identified since the PW1 has identified the bulk of exhibit, we sought to tender the bulk of exhibit, my lord, and evidence before the court.
Mustafa, because I want to translate the proceedings to him.
Court please. Alhaji Abdullahi, kasancewar ka aika ka amsa laifin ka dama. Yau shine ranar da kotun nan za ta yanke maka hukunci. Shi lauya mai gabatar da ƙara ya kira shaida wanda ya bada shaida a kanka gashi nan. Rabiu sunansa. To duka a garin tattara hujjojinsa ya ambaci sunan shaidodi wanda mutane ma'aikatansu wanda suka kawo ka wajensa kamar suna Gido Haruna suka kawo ka tare da wannan kwaya a cikin leda suka bincika kuma suka samu wannan kwaya ya tabbata a wajen ka ne kuma ya yi kwarya-kwaryan gwaji wanda kai kawai yadda ya yi a gaban ka ya yi sannan ya aika Legas wajen ainihin laboratory ma'ana wajen da ake yin gwaji na ƙwararru a can ma aka je aka yi wannan gwaji na ƙwararru aka tabbatar cewa tramadol capsule ne bayan haka nan aka aiko masa sakamakon gwajin da aka yi sake jaddada haka sa'annan kuma ya nemi kotu da karbi waɗannan su ƙwayoyin da kuma takardun da aka yi gwaji da sauransu waɗanda ka sa hannu kamar waɗannan ka sa hannu ka dangwala duka ta zama a matsayin shaida a kanka kuma ya tabbatar wa kotu cewa duka da amincewa ka aka yi wannan abin baka musanta ba saboda haka yanzu dukkan hujjojinsa ya gabatar a gaban wannan kotu ne a farma yanzu ya rage kotu za ta yi hukunci akan ainihin
if those exhibits are the ones when he was arrested.
As the court pleases, waɗannan capsule da aka kama a wajensa wayannan sun tabbata cewa su ne wanda aka kama ka da su ne. He admitted it, my lord.
Okay. Let PW1, how many are there?
There are 5 tablets and 7 pieces.
Okay.
5 tablets and 7 tablets.
The bulk of the exhibits comprising of 5 sachets, Tramadol tablets concealed inside a white paper is hereby marked as Alhaji Abdullahi.
My lord, that's all for PW1.
Madam Mustafa,
My lord.
can you ask the defendant if any questions to ask officer based on the exhibits and what the officer has just informed the court, testified before the court?
As the court pleases, kotu ta ce a tambaye ka, kana da wasu tambayoyi da za ka yi wa shi wanda ya bada shaida a kanka yanzu? Da ba wani tambayoyi ka daga murya kotu ta ce. Sai ba zo jan ba ka ce abin da ba na afuwan ba. Kana da tambayi da aka yi babu.
Whether the facts and statements exhibit officer and all the exhibits presented reflect the true position of King.
As the court pleases, kasancewa shi wannan bai ba da shaida a kanka da su waɗannan ƙwayoyi da aka gabatar a gaban kotu da waɗannan takardu da aka ciccika ya tabbatar da gaskiyar tuhuma da ake maka a kan wannan laifi. He said, yes, my lord, it reflects the true position of what is being arraigned before this court.
Yes. Prosecuting counsel.
Yes, my lord, we applied for the witness, my lord, to be discharged from the witness box.
Application granted. Thank you, officer.
Thank you, my lord.
My lord, we applied for the defendant, my lord. Charged, my lord. Thank you.
Madam Mustafa asked any cause to show why he should not convicted as charged.
As the court pleases. Ana da wani hujja ne wanda za ka gabatar wa kotu wanda kotu ba za ta zai hana ta hukunta ka. Ba ka da shi? He said he don't have any reason why he will show to the court that he will not be convicted.
The defendant who is not literate in English language indicated that he wanted the charge read to him in house. He pleaded guilty to the counts in the state charge when arraigned earlier. The learned prosecutor indicated his intention to conduct a review of the facts of the charge to which the court adjourned to today or review of facts. This was an exercise which is peculiar to drugs and related offenses and was not meant to require the prosecutor to prove the allegation against the accused person, which the defendant himself had voluntarily pleaded guilty to by the provision of the law, except in capital offenses. Once an accused person has pleaded guilty to an indictable offense, to an indictable felony, punishable with a term of imprisonment, the court is empowered, especially in relation to Federal High Court, who by Section 33, Sub 2 of its Enabling Act, Cap F12, Laws of the Federation of Nigeria, 2004, empowered to try criminal cases and matters summarily, to proceed to convict the defendant. The exercise to do a review of the facts of the charge was consequently done today, the 28th day of October, 2022. I've listened to the learned prosecutor, Usman Bamala Esquire, who has produced certain documentary and real exhibits which have been admitted in evidence. Exhibits NDLEA Alhaji Abdullahi 1A, B, C, 2A, B, C, and 3 have proved that the bulk of the exhibits seized and recovered from the possession of the defendant is a narcotic substance. It is one of the substances which the extant legislation, that is the National Drug Law Enforcement Agency Act, Cap N40, Laws of the Federation of Nigeria, 2004, have outrightly prohibited its sale, possession, or consumption. The defendant, who on arraignment pleaded guilty to the charge, has not produced any evidence of lawful possession of exhibit NDLEA Alhaji Abdullahi 3. I'm satisfied against his plea of guilty and the scientific proof of exhibits NDLEA Alhaji Buhari 2A, 2B, 2C, that the case against the defendant has been proved beyond reasonable doubt, as is required by sections 137 and 138 of the Evidence Act 2011. in view of the plea of guilty entered by the defendant and in line with the provisions of sections 274 sub 1 and 2 of the Administration of Criminal Justice Act 2015, this court hereby find the defendant Alhaji Abdullahi guilty of knowingly found and arrested in possession of tramadol tablets and thereby committed an offense contrary to and punishable under Section 19 of NDLEA Act, Cap N30, laws of the Federation of Nigeria, 2004. The defendant, Alhaji Abdullahi, is hereby found guilty and convicted as charged. I shall listen to the allocators of the convict before I pronounce on his sentence. It shall be the judgment of this court on the basis of the charge brought against the convict. Any record of previous, okay, go ahead and interpret first. I can't hear you. I think your microphone is mute. Okay.
Kasancewar ka amsa laifinka, kuma shi lauya mai gabatar da ƙara ya gabatar da hujjojinsa a gaban kotu wanda ya haɗa da takardu da ya gabatar da kuma shi wannan capsule da aka kama ka da shi na tramadol. Bayan dukkan hujjoji da ya gabatar wa kotu, daga ƙarshe kotu ta gamsu da hujjojin da ya gabatar mata, kuma kotu ta same ka kai mai laifi ne yanzu. Ta gamsu cewa ka aikata wannan laifi. Saboda haka yanzu kotu za ta shaurara ta ji a wajenka wani sassauci za ka nema a wajen kotu game da hukuncin nan da kotu za ta yi maka.
Any record of previous convictions?
My lord, the convict has no previous record. He did not disturb investigation. And my lord, he is still young to have great.
Counsel, I didn't hear you.
My lord, I said and he did not disturb investigation. And my lord, considering my lord, 25 years old, very young, and we pray to be good and better person in the society. Thank you.
How old?
25 years, my lord.
Hajji Abdullahi, kotu ta tambayi lauya mai gabatar da kara cewa ka taba aikata irin makamancin wannan laifi wanda aka kama ka wajen su ya ce a baka taba aikata irin wannan laifi ba da aka kama ka da shi, wannan shi ne karo na farko. Kuma ya ce baka ba su wahala wajen bincike ba. Daɗin daɗawa kuma kai matashi ne wanda kana da ƙarancin shekarunka 25. Wanda yana maka addu'ar fatan alkhairi, Allah ya sa wannan shine karshe, zaka canja ka dawo mutumin kirki. Abin da ya gaya wa kotu kenan. Kotu kuma ta ji as the court pleases.
Does he have anything?
Pardon, my lord?
I said, does he have anything to say to the court?
As the court pleases, kana da wani abu da za ka gaya wa kotu ko alfarma ka? Kadaga
Let
murya
him-
kotu ta ji.
I cannot hear him.
Kotu ba ta jin ka, kadaga murya.
Na neman abubuwa ko da yanke mun hukunci da sassauci a gaban iyayena ni ne babba saura gani na duk mata ne to mahaifina ina jira na haifo min da mahaifina saboda haka ba wani mai taimaka min da yau ina neman abubuwa ko da yanke mun hukunci da sassauci.
Kenan kotu ta ji. Alo, you say that you want the honorable court to
I
temper
want you
justice
to
with
interpret. I can hear him. I can hear him. I just needed him to speak gently.
court, please.
He said he's the eldest in his family.
Yes, my lord.
I want to hear from him.
Kadaga murya ta ji.
Na'am
Ka sake mene.
ya mai jama mai shirya ina neman abubuwa ko da yanke mun
Tell
hukunci.
him to take it one after the other.
Ɗaya bayan ɗaya a hankali. Ana rubutawa.
Ya mai jama mai shirya ina neman alfarma ko da yanke mun hukunci da sassauci.
Mun ci gaba.
Yanke mun hukunci da sassauci saboda a gaban iyayena ni ne babba kuma ba wani mai taimaka min illa mutum sauran ƙannena duk mata ne.
Yes.
Sauran ƙannena duk mata ne ba mai taimaka iyayena illa mutum ina jiran na aka haifo min mahaifina yau.
Yes.
Saboda haka ina neman kotu da yanke mun hukunci da sassauci. Amini alfarma.
Tell him, said he's the eldest in his family and only male.
Yes, my lord.
And from what he said, that he will not commit the offense again. What is he telling the court?
Ka baka nuna kamar nadama ka nuna ba.
Gaskiya na yi nadama.
Kadaga murya a ji.
Na yi nadama sosai. Gaskiya abin da na yi.
What do you do for a living?
Sana'ar ka.
Na noma ne.
I didn't hear that.
He say he is a farmer. Daga muryan ka wani abin da kake gaɗan ne za ka samu sassauci kana jin yin magana.
Then the substance found in your possession, the substance is found in his,
Yes, my lord.
what is he doing with tablets?
Wannan as the court please, wannan kwayoyi da aka kama a wajen ka, me kake yi da shi?
Ina amfani da shi. Ina yin da shi domin yana taimaka min ta aikin gona. Don bangaren noma.
Ask him, doesn't he know are prohibited?
Baka san cewa wannan kwayoyi doka ta hana amfani da su ba?
Da ban san da
Ka buɗe murya.
ban san da haka ce kuma na yi kuskure. Mutum yana da doka ta nemi wa kuma haihuwa. Na yi nadama kai.
Say you don't know that it is prohibited by law, but he is now regretting what he has done.
Where did he get it?
Ana ka samu.
A nan ne dai a kasuwa ana irin masu kallon na saya domin zai shiga cikin gona.
He said he bought it at market from retailers.
from peddlers.
Yes, my lord. As the court pleases.
Madam Mustafa, you can have a seat.
Thank you, my lord.
This honorable court haven't listened to the suggestion made by the convicts, the submissions of prosecuting counsel will deliver the sentence. I don't know whether to sentence down or this case will be the 10th day of November 2020 for sentencing. 10th day of November.
As court pleases.
As court pleases.
Is that the last case, Madam Mustafa?
Yes, it's the last case, my lord.
Okay.
Yes, my lord.
Where? Okay, counsel, thank you so much.
Thank you, my lord.
Mustafa, thank you so much for the services you have rendered.
Thank you, my lord.
The people at the correctional center, thank you.
Thank you, my lord. Thank you, my lord.
I think this is it for today.
Yes, that's all for today, my lord.
Okay, okay, thank you, bye-bye.
Thank you, my lord.